And I would like to note, to please note that this session is being recorded, that if you do not consent to being recorded, we would like to ask you to drop off the session at this time. Thank you very much. We'll give everyone just a brief moment to drop off the session if you so choose. All right, so again, welcome and thank you so very much for joining us here at our Learning Institute. It is a domestic violence prevention and learning institute as part of a cooperative agreement that we have at National Indian Health Board, featured this year at our National Tribal Public Health Summit. My name is Nathan Billy. I'm the Director of Behavioral Health Programs at the National Indian Health Board, and I'm very honored to be your moderator for today's session. Today, we're very grateful to have our subject matter experts, our speakers, Kelby Kennedy, Kelly Stoner, and Alex Cleghorn, who we will be discussing in greater detail and presenting some information on their background here in just a moment. This session focuses on protecting Native women, and it looks at tribal provisions in the reauthorization of the Violence Against Women Act in 2022, or what you will hear us referring to as the Vawa reauthorization pretty commonly throughout the presentations. We are, again, so grateful to have Kelby and Kelly, who will be speaking primarily to a lot of the implications for our lower 48 states, and Alex Cleghorn, who will be speaking primarily to the implications for the Alaska specific portions in those tribal provisions. The session is scheduled to run between 3 and 5 p.m. Eastern.
Please feel free to put questions in the chat as we go along during our different presentations. I know Nathan's going to keep an eye out in the Zoom chat to pull questions. And as he said, my name's Kelby Kennedy, a citizen of the Choctaw Nation of Oklahoma that works for the National Congress of American Indians. It's been a real pleasure to work at NCAI and Vawa, particularly as we've led up to the Vawa reauthorization that just happened in March. And so to give you a quick overview of what we're going to look at today, we've broken it up into about 5 sections. So I'm going to give you kind of setting the stage and mobilizing for change. What's kind of the background on the Violence Against Women Act? How does it impact our communities? Kelly Stoner is going to give you an overview of comparing VAWA 2013 and VAWA 2022. Alex is going to give you a great in-depth look into the Alaska Tribal Public Safety Empowerment and what's happening on the Alaska side. We're going to then, Kelly and I are going to come back and briefly talk about the different resources for VAWA that are open and available to you here today. And then we're going to open up a Q&A session. So we've got a lot of great info going on and we'll hop right into that. So Violence Against Native Women Act, setting the stage and mobilizing for change. So just to talk very briefly and just a quick reminder for some folks, when you come into the session, you come in live. So we can definitely all hear a couple of folks in the background just to make you aware of that. So in terms of access to justice in Indian country, having access to justice in your community directly impacts the health in your community. If people cannot be safe, if they're not able to have bad actors be accountable, it will impact health in your communities in a variety of ways, and definitely excited to kind of expand on that a bit more during our Q&A time. But for history purposes, tribal nations have been able to hold bad actors accountable throughout the Americas since time immemorial. So very long, way before non-Indians came to this country, we were able to hold anybody that was a tribal member, a non-tribal member, a non-Indian, accountable in our communities in tribal justice systems. And what you have when the United States comes around is there are different pieces of legislation where Congress restricts how tribal nations can hold different tribal members accountable. So you have acts like the Major Crimes Act, the Indian Country Crimes Act, Public Law 280, where Congress restricts that ability for tribes to hold people accountable in our own communities. In addition to that, and really what the focus of a lot of our VAWA conversation will look at is the impact of a case from 1978 called United States Court, or called Oliphant versus the Squamish Indian tribe. In that case, the United States Supreme Court actually restricted tribal nations' ability to hold non-Indians, so people who are not a member of your tribe, people who are not a member of another tribe. They really restricted the ability for us to hold non-Indians accountable in tribal justice systems. And that really is not, when you look in the grand scheme of history across the United States, that is the uncommon thread. So the common thread is tribes being able to hold everybody accountable in our justice system, just like you would hold somebody accountable if you committed a crime in Ireland or France or Japan. Tribal nations had that authority, and then it was being restricted by the federal government, again, through acts through Congress, and then by the US Supreme Court in 1978 with what you will know as the Oliphant case. So when we have that restriction of being able to hold bad actors accountable, tribal nations have to rely on outside governments to hold people accountable. And oftentimes that ends up being the federal government. In some public law, well, in public law 280 states, that ends up being the state government in some regards. But what we see wholeheartedly across the entire nation is violence against Native women really rises. And I don't want to read out every single horrible statistic on this slide, but I do think it's important to really note, that the CDC even recently noted that the third leading cause of death for American Indian Alaskan Native women is homicide for women who are between the ages of 10 and 24. And it's the fifth leading cause of death for American Indian Alaskan Native women between the ages of 25 and 34. 84.3% of American Indian Alaskan Native women, more than 4 in 5 have experienced intimate partner violence, sexual violence, or stalking in their lifetime. I mean, these are really high statistics throughout Indian country. And a lot of what we found when looking at this information is a lot of this experience happens at the hands of a non-Indian perpetrator, somebody who tribal nations cannot hold accountable in our own justice systems. And I want to make sure that we're also highlighting that in addition to various other violent crimes, stalking is a big issue in Indian country, and being stalked by non-Indian perpetrators. We're also more likely, 5 times as likely to experience violence by an interracial partner as opposed to a non-Hispanic white woman. One of the biggest statistics on here, though, is in addition to all of these high rates of violence against Native women across Indian country, this last statistic that was pulled from, I believe it's 2010, I'll have to double check my notes, but I believe it's 2010, that showcased that US attorneys at the time declined, even though there were these high rates of violence, they declined to prosecute 52% of violent crimes that occurred in Indian country, and that 67% of those cases that were declined were sexual abuse related claims. So this means that, in addition to not having the ability to prosecute bad actors in your community, the government that is supposed to protect your community to make sure that everybody is safe and healthy is not prosecuting some of the most horrendous and violent crimes in Indian country. And one of the members of the House that we've worked with for years on Vawa always likes to say in the press that hunters know where to hunt, right? That means that people know where they're not going to be held accountable, and so they can come and really target American Indian, Alaskan Native women, and you can see that in a lot of the statistics. Because of all of these different congressional acts, because of the Oliphant case, the US Supreme Court, don't worry, I'm not going to test you on this chart later, but I think the title of the slide really kind of lays it out. Indian country jurisdiction. It's complicated. It's really complicated. And you have to ask a series of questions of who, what, when, and where. Who is the victim and who is the defendant? Is it a tribal, a Choctaw person versus a Choctaw person? A Choctaw person versus a non-Indian? Is it non-Indian versus non-Indian? Who really matters? Whoever is the defendant and whoever is the victim. Then you have to ask what kind of crime took place. So you've seen here, it's broken up in terms of major crimes and minor crimes. I don't want to get too much into that, but the type of crime really matters because these different federal laws and Supreme Court cases impact on the type of crime. When did the crime take place? The reason I put that in there is we have Vawa 2022, but the actual implementation for the date of Vawa 2022 comes later in the year in October. So even when did the crime take place may have an impact on being able to hold somebody accountable. And where did the crime take place? So I'm just going to put a disclaimer on this. This is not an accurate chart for Alaska. Alex is the expert on the Alaska provision. This is much more focused on the lower 48. Hopefully have an update for Alaska soon. But where did the crime take place in what is traditionally known as Indian country? So inside of a reservation, on trust lands, on allotment, what counts as Indian country? And so you have all of these questions, and then you have these interlays of federal law on top of US Supreme Court precedent that really restricts the ability of tribal nations to hold bad actors accountable. And it makes us reliant on a federal government, or in PL 280 states, a state government to actually hold people accountable in our community. So it becomes really hard to hold people accountable. But you have to ask yourself, what is the Violence Against Women Act, and why in the world does it matter in terms of tribal jurisdiction? So VAWA, or the Violence Against Women Act, it's one of the first federal laws that recognized that domestic violence and sexual violence were problems across the country. And that didn't originally get passed until 1994. It's had 5 reauthorizations since then with VAWA 2022. VAWA is up for reauthorization every 5 years. And the main purpose of VAWA is to get funding and resources and coordinate efforts around violence against women across the country, not just violence against Native women, but violence against all women. And we luckily have a nice tribal title that we've been able to work into the law throughout Congress. We want to make sure that when you're looking at VAWA throughout the years, you see progress every single time it's being reauthorized. However, it was VAWA 2013 where we realized, hey, this could be a vehicle that is regularly reauthorized that we could start to really educate people and make sure that we have provisions to restore that authority to tribal nations to have jurisdiction returned to us. And so that's why in 2013 and 2022, you see VAWA, the tribal provisions in VAWA really focusing on reaffirming inherent tribal jurisdiction. And that's been very successful for us, as you can see with VAWA 2022. So in 2013, and I won't hop into this too much because Kelly, I know, will do a great job talking about all this here in a bit. But VAWA in 2013, we got 3 crimes returned to tribal nations. Those were domestic violence, dating violence, and violation of protection orders. In 2022, in addition to our 3 original crimes, we got child violence, sex trafficking, sexual violence, stalking, obstruction of justice, and assaults of tribal justice personnel. In addition to restoring tribal jurisdiction, VAWA has been monumental in getting resources for Indian country, ensuring that all tribal nations, as Alex will talk about later, all of the tribal nations in Alaska are able to exercise VAWA jurisdiction, ensuring tribes in Maine are also able to exercise VAWA jurisdiction, setting up a new reimbursement program. There's a lot more to it that are support beams for jurisdiction, because you can't just give a tribal nation, you can't just restore someone's jurisdiction and say, oh, that's going to solve the problem, because you have to be able to help fund justice systems, right? You have to have prosecutors, public defenders, police, a courthouse. There's so much that goes into a healthy justice system. So that's kind of a brief overview in terms of the timeline of VAWA. And we're hoping to have the next reauthorization happen in 2027. So the VAWA fight is not over. We still need to look forward and see, what is it that we need to improve in the next version of VAWA. And so when we look at in terms of improving VAWA, NCAI set up a task force on violence against women in 2005 and really worked together with tribal coalitions, tribal leaders, tribal advocates on the ground, family members, survivors, anybody, basically any tribal citizen or non-Indian ally that wanted to work together to get VAWA reauthorized, to educate Congress, to mobilize, to restore tribal jurisdiction and make Indian country safer for everybody that lives there. And so it really is, the purpose of the task force is to really serve as a unified tribal voice to oppose crimes perpetrated against Native women. Really invite everybody in here. If you haven't been to a VAWA task force meeting before with NCAI, please come. As you can see, it is standing room only. And in the virtual environment, we've been able to have a lot more people come in, but we really hold an environment where we want to identify what are the issues on the ground and how can we all work together as a unit to help change laws like VAWA to be able to make everybody safer in Indian country. And that goes beyond VAWA. And so really encourage you to please come and join. You can shoot me an email. We can add you to the listserv. It doesn't cost anything to join, but just wanted to let you know that that body has been around and working since 2005. In addition to the VAWA task force, which has been around since 2005, in 2013, the Department of Justice set up what is known as the Intertribal Technical Assistance Working Group. It was created in 2013, like I said. There are about 70 tribal nations that participate in that working group, and the purpose of it is to really have peer-to-peer information sharing around tribal nations on how to best exercise special domestic violence criminal jurisdiction. You'll hear Kelly talk about SDVCJ. There's a lot of acronyms. Really, it comes down to the jurisdiction that was restored to tribal nations in VAWA, and the ITWIG, since it was created in 2013, focused on those first 3 crimes. They have a wealth of information. They have regular meetings. They come together on monthly phone calls and also on a biannual basis as well. And so there's the email address right there that will let you know if you want to become a member of the ITWIG or get ITWIG information for your tribal nation. Please feel free to shoot that email a request and we'll make sure that you get the proper information. I know that Kelly and I will talk a little bit more about the type of technical assistance and resources available through the ITWIG a little bit later. So in addition to the Vawa task force and the ITWIG, which was really key, to be honest with you, the ITWIG was really key to hearing from tribal leaders about what were the issues they were running into. So they were prosecuting these domestic violence cases, but they would say, hey, you know, we prosecuted these cases, but we can prosecute dad for beating up mom, but we can't prosecute dad for hitting the kids. And as you'll see here in the statistics from the NCAI 5-year report, that at least 58 of the incidents that tribal nations were prosecuting in those first 5 years of jurisdiction involved children. And so that's the reason that we have crimes like crimes against children, stalking, sex trafficking. It's because tribal nations came together and said, all right, we're going to exercise this jurisdiction. And they would tell us, hey, these are the problems that we're running into. And then on the policy side, NCAI's task force was able to work with other organizations and partners to elevate that information up to Congress. And I know that there were several members of Congress that really cited the 5-year Vawa report as reasons to improve Vawa this time around. So data is going to be really important in this next level of reauthorization to make sure we're accurately tracking, you know, where are the holes, how can we improve in 5 years, and ultimately making communities safer by ensuring that, once again, bad actors are held accountable, that there are systems in place in order to help victims across the spectrum, and making sure that we can go forward and continue to improve the ball. So it took a lot of effort to reauthorize Vawa across the spectrum. And you can see this is at the top, there's a photo of Vawa task force members and members of the House and Senate, all at the Capitol, you know, getting ready to really go down the halls and talk to legislators. There's President Fawn Sharp speaking in front of Congress about Vawa. It's really a all hands on deck effort. So the Vawa task force toolkit, which you can see there on the left, had various pieces of information to help people call their senators, write letters, really know kind of what was the background of Vawa and why was it important. And that education worked. I can tell you, it was so helpful to be able to go to a Vawa task force meeting and tell all of the members, hey, we need to call the Senate on this day. And people blew up the phones. And so we really took that opportunity of working with those out in Indian country to identify what the problems were, you know, getting all of our ducks in the row, getting the information that we needed, and going to educate on the Hill that eventually led to actually having Vawa pass. And again, it was an all hands on the deck effort. Everybody across Indian country contributed, and we were very happy to be a part of that effort. So if you didn't stay up in early March until 11 o'clock watching an omnibus vote like I did, like it was the Super Bowl, it was very helpful to, not just helpful, it was really gratifying to see senators coming together. There was a lot of background conversations that happened in Indian country, like I said, came to bat in full force. Tribal leaders, tribal citizens, coalitions, advocates, non-Indian allies really came full force, called in mass. And because of that, we were able to get Vawa introduced with not only 10 Democrats, but 10 Republicans. And that was the thing that really helped us get over the line. Is it was the ability to get over the filibuster threshold that's needed in the Senate. And so ultimately it got put in a giant bill called the Omnibus in order to fund the government, and that had to get passed in March. And that's why you don't just see like a single Vawa bill being passed, it's because it's in this larger funding bill. Ultimately, like I said, it really is an all hands on the deck effort. It's going to take everybody working together throughout Indian country, again, to make sure that not only are we preparing to improve Vawa going forward, but that we are helping tribal nations being able to implement Vawa. You might have questions about, you know, I don't know if my tribal nation's implementing Vawa or how Vawa could be related to the work that I'm doing. And I think I know that Kelly is going to talk a little bit about how this type of provisions can really direct healthcare workers in particular. And I think as long as we continue to think in out-of-box ways, as long as we continue to approach this through a tribally supported lens, reaffirming tribal jurisdiction, everybody working together to get as many resources as we possibly can out in Indian country, everybody working together to get as much information that we can, that ultimately I can see us being very successful again in 2027. But what that will take is everybody coming together, learning what's going on, you know, talking about what are the problems and what are the solutions and how we can move forward. So there was a lot of really lot of really intense stress moments to get the bill across the way, but everybody who really went to Congress made it possible to have this law go across the way. So that's all I'm going to say on a background of Vawa before I hand it off to Kelly Stoner. Again, I want to say Yakuke. My name is Kelby Kennedy, a citizen of the Choctaw Nation of Oklahoma. There's my phone and email. NCAI also did a wider presentation on Vawa that includes several of the folks the folks that are here today in a PowerPoint. So I linked that as well in case you want to have a longer deep dive in addition to this really great opportunity that NHB has as well. So with that being said, I am going to hand the floor over to Kelly to start talking about comparing Vawa 2013 and Vawa 2022. Yakoke, thank you so much. Kelly, the floor is yours.
Thank you so much, Kelby. And I'm going to be drawing on some of the pieces that you've already provided today. I'm Kelly Stoner with the Tribal Law and Policy Institute. Thank you all for having me. I'm going to be moving in to a presentation on some of the highlights, including the covered crimes that Vawa 2022 expanded over the Vawa 2013. So if we'll go to the next slide, and thank you, Kelby, for running my slideshow. I'm in rural Oklahoma with a little bit of internet difficulty, so let's see how this goes. Kelby put some statistics up early on in her slideshow, and I'm not going to go over these. She's already covered those very well, but I wanted to demonstrate to you that this omnibus bill, and there it is at the top there, you see HR 2471, 849 is the page number. I wanted to really kind of build a foundation here and emphasize these were congressional findings. This is the platform from which Congress launched Vawa 2022 to address the needs of some of these statistics here. And I won't go through that, but again, a couple of more finding slides here because I think it's super important to ground us in what Congress was seeing and hearing and believing as they put together Vawa 2022. Another piece of this was, and I think this is really important, you heard Kelby refer back to a couple of reports from NCAI, and that really, I think, played at least a role in getting Vawa 2022 passed. But I want you to just take note of this. Now, the tribes that Congress is referring to here are the Vawa 2013 tribes, those tribes that are exercising special domestic violence criminal jurisdiction, or SDVCJ. And as Congress looked back on the report and listened to testimony, Congress found that the tribes that were exercising SDVCJ over those three crimes that Kelby pointed out earlier, dating violence, domestic violence, or violation of a protection order, of the tribes that were prosecuting those crimes against non-Indians, that Congress reports significant successes in holding these violent offenders accountable for those three crimes. In fact, TLPI, as well as NCAI, I have actually in person been at with the ITWIG that Kelby mentioned earlier, the Intertribal Working Group, since 2013. I've had the honor of watching those first few tribes and all tribes that came later to step out and once again be able to exercise this criminal jurisdiction over non-Indians committing these three crimes in Indian country. And I can tell you, up until today, I believe, no non-Indian has followed through on any habeas corpus appeal, not one. In other words, tribes are meeting the due process requirements of non-Indians and continue to experience success at exercising this special domestic violence criminal jurisdiction. Next slide. One more finding slide here. Tribal prosecutors for Indian tribes exercising this SDVCJ report that the majority of domestic violence cases, as Kelby mentioned earlier, involve children, really stepping up to say there's nothing we can do when the non-Indian assaults a child, even if it's domestic violence and dating violence, we can't get at that. And so that was a huge gap identified in the 5-year report that Kelby mentioned earlier. So once this 2013 got was building up steam and tribes began exercising this criminal jurisdiction over non-Indians, committing these 3 crimes in Indian country, big gaps were identified. Let's go to the next slide, please. So I'm going to talk about VAWA 2022. I'm going to give you some highlights, and then I'm going to take a bit of a deeper dive into the covered crimes. So just to highlight for you, VAWA 2022, we don't call it SDVCJ anymore, which is going to be a very difficult change for me. Since 2013, we've been saying SDVCJ. Now it's called Special Tribal Criminal Jurisdiction, or STCJ. Also, the term covered crimes is used in VAWA 2022 to identify the categories of criminal conduct that tribes now that meet these requirements may now exercise criminal jurisdiction over. You heard Kelby talking about the Oliphant case. That again caused, just in addition to a disrespect for tribal sovereignty, really left a gaping opportunity for non-Indians to come in and commit these 3 crimes in Indian country, and oftentimes they would go unpunished. So these covered crimes are crimes where the federal government now is saying through VAWA 2022, tribes, you know those restrictions we put on you with that Oliphant case? Well, we're relaxing those restrictions now. And now there's going to be 9 covered crimes, not just 3. So VAWA 2022 changed what could be charged against non-Indians committing these crimes in Indian country and who can be charged. And I'm going to do a bit of a deeper dive in that. So can we go to the next slide, please? Here are all of the covered crimes under VAWA 2022. And you'll see I've got some crimes up here that say 2013 and 2022. Domestic violence, dating violence, and protection order violations were covered categories of crime in 2013. They are again covered in 2022 with some changes. Seems like small changes, but as a former tribal prosecutor, I can tell you they are big changes with respect to a prosecutor's potential ability to bring these crimes and get a conviction. We also see, based in part on what Kelby was talking about earlier, it was really a concerted effort by so many partners. We have sexual violence now is a category of crime. Stalking now. Sex trafficking is a crime that's covered now under VAWA 2022. And let me just reiterate, Kelsey pointed this out earlier, October 1, 2022 is the earliest tribes can exercise this special tribal criminal jurisdiction over non-Indians committing these crimes. And it may take longer for some tribes as they decide whether or not they need to amend or even draft their tribal codes. Child violence, you saw that in, and Kelby brought it up and I brought it up again. Child violence can involve criminal child abuse, criminal child neglect, a whole host of different crimes might fit under that category. Obstruction of justice, very interesting that you'll see this come forward. I'll talk about that in a few minutes, a deeper dive, because I really feel like all of these crimes are going to affect some of your work as public health workers in Indian country, but also it's going to lend some protection to you as you do your work in Indian country when these crimes are being committed. Assaults against tribal justice personnel probably means a broader brush than what you're thinking. And again, these are the covered VAWA 2022 crimes. We can go to the next slide, please. So I'm going to bounce back and forth between 2013 and 2022 so you can get an idea of some of these changes. So look at the 3 crimes that tribes that met the due process requirements set forth in the federal statute. Those were the 3 categories of crime that tribes could prosecute non-Indians for committing in Indian country. Now look at the next piece of the slide with the check marks there. This may not seem much to you all, but as a prosecutor, it adds burdens. It's just layers and layers of we have to plead this, we have to prove it in some way. So we had to prove that the crime was committed in Indian country. The victim must be an Indian. The defendant must have sufficient ties to the community. I'm going to go over a slide that's going to explain that to you, just to give you a little bit of an idea of what tribal prosecutors were faced with under SDVCJ. And also, we see these due process requirements, only one small change under VAWA 2022, but some of the due process requirements that tribes, over 30 tribes now implementing or already meeting and providing to defendants in these cases. Indigent defense counsel, they get a lawyer if they cannot afford one. Many tribes are just affording every non-Indian defendant a criminal defense attorney. And also there has to be a jury pool. That's the group of folks that get called in for jury duty, not the ones necessarily they're going to be seated on the panel, but the ones that get called in have to reflect a cross-section of whatever that tribal community looks like, and many times that will include non-Indians being pulled in to serve on a jury. Next slide. Okay, here are those sufficient ties. So this again would be the ultimate responsibility of the prosecutor, even though it could go back and forth with some different criminal process rules. We have to show that the defendant resides in the Indian country, is employed in the Indian country, or is a spouse, intimate partner, or dating partner of a member, or the spouse, intimate partner, or dating partner of an Indian who resides within the Indian country. That's in addition to proving the elements of domestic violence, dating violence, or violation of a protection order. So you get the picture. Not the easiest set of circumstances for the tribal prosecutor. Next slide, please. Okay, in contrast, this is VAWA 2022. So we can now prosecute dating violence, domestic violence, or violation of a protection order, and all of these other crimes listed in the bullets. Now, what about those sufficient ties? That has totally been removed in VAWA 2022. Notice that the crime still must occur in the Indian country. The victim must be an Indian for certain crimes here. I'll go over that in just a few minutes. And the defendant's ties to the community no longer have to plead that, prove that in any way, shape, or form. The due process change here is that the defendant, the non-Indian defendant, must be provided notice of their Indian Civil Rights Act rights under the Indian Civil Rights Act, and the right to habeas corpus, to have a federal court review the jurisdiction of the tribe. So next slide. I love this next slide because look, it's all zeroed out here. No longer have to worry with these tedious pleadings and provings of these particular pieces, as we did under VAWA 2013. Next slide. Okay, let's talk about what can be charged. Now, I've listed the covered crimes for you. I do want to tell you that domestic violence and dating violence, one of the pieces that we had to prove under 2013 as tribal prosecutors was that violence committed piece. That's what the statute required us to prove. There was a U.S. Supreme Court case that made some of the first Itwig tribes wonder if that meant physical violence. There was some confusion over that, made these crimes a little more complicated to prove. And the violence committed language in 2022 is gone. We no longer need to show that. And in fact, one of the big pieces, if you look at this omnibus, you will see that we didn't necessarily see in 2013 is a heavy reliance on tribal law. In other words, whatever the criminal law of the tribe says, let's go there first. And in some of the covered crimes, there are some required federal elements, but always defaulting first in the majority of those crimes, not all, to tribal law. Next slide. Again, kind of emphasizing the importance of tribal codes. That's going to be important because we're going to do some resource slides at the end to provide some information on how tribes might access that or assistance doing that. Who can be charged? In most cases, we have to have that Indian victim. There are two crimes, though, and I think these crimes will be important for some of you working in public health and providing services in Indian country. And those crimes are obstruction of justice or assaults against tribal justice personnel by a non-Indian. So let me just say why I think this is I didn't do a deep dive into these, but I do want to leave you some information. There is, in addition to Oliphant, we've seen that partially overruled by Vawa 2013, even more more crimes now, a wider swath, if you will, of overruling of that Supreme Court case of Oliphant. Now we know there is a case, and Kelby has this listed in her jurisdictional chart. Anytime there was a non-Indian committing crime in Indian country over a non-Indian, those crimes typically would go to the state. There may be some variations of that, but what we know is Congress says anytime there's obstruction of justice or assaults against tribal justice personnel, it doesn't matter if it's non-Indian v. non-Indian. Tribes can prosecute those crimes, and that is a partial overruling also of that McBratney case. So now we're seeing more Supreme Court cases being overruled by Congress. And I will say that tribal justice personnel is a very, very broad definition. I would encourage you to take a look at the omnibus or reach out to Kelby or myself if you want a deeper dive into that. It does have to be connected to one of those covered crimes, the assault on tribal justice personnel. But if it is associated with covered crimes, in some instances, it will cover all service personnel that are working, assisting with investigation, assisting with the prosecution, providing services to the defendant. So be thinking about that, because that, to me, was huge in some of the areas you all will work in. Obstruction of justice, again, can be non-Indian v. non-Indian, but it's going to default back to tribal criminal law. However, the tribe has defined those crimes, but again, overruling. Again, I've already talked about the ties to the communities overruled. Maine was, I think, prohibited by state or state constitutional law over exercising this jurisdiction. That was clarified. And in just a few minutes, Alex is going to do a deep dive into the Alaska specific provisions. So I'll save those for Alex. Next slide. The due process provisions I went over with you earlier. It's this written notice to the defendant of all the rights and privileges and the right to habeas. So we're working with the Itwig tribes on what that might look like. And also, in 2013, we didn't have this written requirement to the non-Indian defendants that say, before you go over into federal court to test whether the tribe had jurisdiction over this case, before you go over there, pursuant to a writ of habeas corpus, you have to go all the way up the appellate process the tribe has in place. That's not mandatory. Tribes have that in place, but if they haven't, you have to let the tribe take all of these opportunities to evaluate and make findings whether the tribe has jurisdiction. So just know that that wasn't in writing. We were thinking that was true in 2013. Now in 2022, we get it in writing. Without a doubt, that has to take place now before, unless the exceptions apply always, but it's going to have to take before the defendant can go over, they have to exhaust their tribal appellate remedies. Next slide. And that's it for me. Again, Alex, I think you're going to be up. And Kelby, I'm going to let you turn it over to Alex.
Perfect. Thanks so much, Kelly. We're doing the great thing that everybody's had to learn over the pandemic, which is how to quickly swap out slides. And Alex has it going on. So I will turn the floor over to Alex. Thank you so much, Alex.
Thank you, Kelby and Kelly and Nathan. Chumai, and good morning. It's still morning here in Alaska and Anchorage. And I want to thank the NIHB for hosting this event and for the invitation to speak to you about Alaska. And also want to recognize that NIHB is, treating domestic violence and public safety as public health issues, as we know that they are. And I want to thank all of you for attending and for the work that you do in your communities on this issue. Nathan introduced us all at the beginning, so I'm just going to take a short minute and tell you who I am. My name is Alex Cleghorn, and I'm the legal director at the Alaska Native Justice Center, which is here in Anchorage, Alaska. I was born here in Anchorage and grew up mostly in Fairbanks. And I'm a tribal citizen at Dogdignac, also known as Woody Island, as well as a shareholder in our village and regional Alaska Native corporations. I've been a tribal attorney for almost 20 years, which is hard to believe for a few reasons. And when I first came home to Alaska, I worked at South Central Foundation, which is the regional primary care service provider for Alaska Native people. It's a Alaska Native institution. And so my experience there informs some of the public safety and justice work that we do every day at the Justice Center. So we're going to talk a lot about Alaska. And before we get to the tribal provisions of Vawa 22, I'm going to tell you a little bit about my homeland and what's different here, because I think that that's important to understand as we look at subtitle B, the Alaska Tribal Public Safety Empowerment section of Vawa 22. I'm also going to share a little bit about what ANJC does and how we serve Alaska Native people as well as Alaska tribes. So what's different about Alaska? Well, it's not just how big we are, though we are big. And often when I share this slide, I like to contrast our size and the number of people here with wherever I'm speaking from, but I'm speaking to you from Alaska today, so I can't quite do that. But we're very large. We have 229 federally recognized tribes out of the 574 throughout what is now the United States. And we have at least 180,000 tribal citizens living in the state. Overall, Alaska has about 733,000 people in the entire state. So that is, I guess, even less people that live in the Bay Area, where I lived for a number of years. About half of those people live in the Anchorage Matsu area, which is where Anchorage is, and the rest are scattered throughout the state. So not only are we big, but like a lot of states, our Alaska Native people and cultures are not a monolith. We have a variety of different cultures and languages throughout Alaska. And I think that it's important to recognize that when we're talking about Alaska, that not every tribe or every region approaches things in the same way or with the same values. And so there is not one size fits all approach or solution in Alaska. And it's important to go into any work in Alaska with that in mind. I know that sometimes that is frustrating for our state and federal partners who want a single solution. but we know that that just does not work for us. I'm going to talk a bit about our history here because I think that it provides a context that's very important to understand how we got to where we are now. So our outsiders, our initial colonizers in Alaska were Russians. And so you will see Russian onion dome churches throughout villages in Alaska. And there are people who continue to practice Russian Orthodox religion. You may hear references to an old calendar. Some regions, including my own, Kodiak, celebrate feast days and holy days on the old calendar. So that means we've got to keep two calendars in mind when we're scheduling different events in the region. From the Russians, there was a treaty of cession and sale to the United States. And Alaska Native people were mentioned in that treaty and that sale. And it said that inhabitants of the ceded area, if they should prefer to remain in the ceded territory, they shall be admitted to the enjoyment of all the rights, advantages, and immunities of citizens of the United States. But it accepted, it says, with the exception of uncivilized Native tribes. We're not given rights, citizenship, advantages, and immunities of citizenship. So from the beginning, Alaska Native people and uncivilized tribes were treated differently. You all heard of the gold rush in Alaska. I think what is important to remember here is that there were more than one. There were successive gold rushes throughout the state that brought outsiders seeking their fortune with the idea that they were going to find gold laying on the ground and make it rich. So I've highlighted some of the gold rushes here. Hope is down here by Anchorage. It's just across the Cook Inlet. The Klondike, of course, Nome up far north, and then Fairbanks in the interior. So each one of those locations faced gold rushes and outsiders who came in seeking that resource. We do have some federal recognition of Alaska Native people and tribes. So in 1905, there's the Nelson Act. There's also a few other federal acts that recognize that Alaska Native people are here and are being treated differently. In 1995, we have statehood, and at statehood, Public Law 280 applies to the state of Alaska. Important to remember is that at that time, there were reservations throughout the state of Alaska. And of course, that was changed with ANCSA. But the main impact of Public Law 280 in Alaska is the resource issue that Kelby highlighted. So with shifting that public safety responsibility from the federal government to the state government, first, it didn't diminish tribal jurisdiction, but it did shift and I guess make more narrow federal jurisdiction and the resources that went along with that. And what that has meant in Alaska and other Public Law 280 states is that there is not federal money that we can self-determine under the Indian Self-Determination Education and Assistance Act. We can't 638 that money and reprogram it to address these public safety concerns in our community. That's a real impediment to addressing these issues because tribes are applying year after year for competitive grant programs to support public safety and justice programs in Alaska. In 1968, we have oil discovered in Prudhoe Bay. And from the time of the Russians until 1968, there was this question of Alaska Native people and our claims to the land, and a push and lawsuits to try and settle those claims over the years, over the 100 or more years. And suddenly with the discovery of oil, those land claims were settled within 3 years. the federal government made a condition on accessing that oil on settling the land claims. And this year is the 50th year anniversary of ANCSA. I'm not quite as old as ANCSA, but I'm getting there. And there's been a lot of discussions in Alaska about what ANCSA is, what it did, and how it added this additional layer of Alaska Native institutions into the landscape that the lower 48 doesn't have. This idea of Alaska Native corporations that own the land without terminating the tribes, which are still the governments, and how ANCSA corporations and tribes can and do work together, though sometimes not in the best way. In 1978, we have the passage of ICWA, and I highlight that because most of the litigation around jurisdiction in Alaska and Alaska tribes centers around ICWA and child welfare. And I'll flesh that out a bit more as we talk about some of the case law that led us to where we are today. It wasn't until 1993 that the question, at least according to the federal government, was definitively answered. It was the 1993 List Act and the 1994 amendment to that that included a tribe that had accidentally been left off, where the question of tribes in Alaska from the federal perspective was answered. It took a little bit longer for the state of Alaska to recognize that, but with that federal recognition, that issue became more clear. And then I highlight two cases here that you may have heard of. We have the 1998 Vena, Thailand decision. And that was the case where the US Supreme Court found that a former reservation land that was transferred to an ANCSA corporation and then transferred back to the tribe was not 1151 B Indian country, the dependent Indian community. And the reason I make that so specific is, as a tribal attorney and as a tribal advocate, we like to point out how narrow that decision was. It was not holding that there is no Indian country in Alaska, because that's not true. We have nearly 1 million acres of town sites, allotments, and individual allotments that are Indian country here. And so that broad brush description of Vena Thai is not entirely accurate, and we like to keep it narrow. And it wasn't until 1999 and John versus Baker, which was an Alaska Supreme Court decision, that we really start to see the tide turn, and a recognition that tribes in Alaska have jurisdiction over tribal citizens regardless of the status of land. But before we get to the 1999 decision in John v. Baker, I want to highlight both the decisions of courts and the litigation positions that the state took in the 80s and 90s about the status of tribes. So in 86, we have a court that says PL 280 took away tribes jurisdiction under ICWA. They looked at PL 280, they looked at ICWA, and they said, Alaska tribes, you don't have jurisdiction under ICWA. And in 88, we have a decision that says Alaska tribes are not like tribes in the lower 48, and Alaska tribes are somehow different than tribes in the lower 48 and the description of tribes in federal Indian law. And then in 92, tribes without reservations lack authority of a sovereign government. So these decisions are part of why that 93 List Act was so important and revolutionary, and why the 99 decision in John v. Baker was so important. I'd highlight here that we've got folks who are signing in and out, and you're not automatically on mute, so we can hear you unless you've muted yourself. So again, we turn back to John v. Baker in 1999, where the Supreme Court, the Alaska Supreme Court, says that tribes exist in Alaska and that we retain inherent sovereignty around core tribal matters, and that sovereignty is tied to citizenship, not land, right? Tied to tribal membership or citizenship and not land. And then in 2010, we have a federal court decision that explicitly overturns some earlier decisions around ICWA and the state being compelled to recognize tribal court adoption decrees under that full faith and credit requirement in ICWA. And again restates Indian countries not required, that jurisdiction over citizens is independent of jurisdiction over land. We have decisions continuing on into the 2010s. And part of the reason I share these is not just for the holdings in these cases, but to illustrate how recent this history is. This is not ancient history in Alaska. This is recent history. And in part, this recent history, it continues to impact the relationship between Alaska tribes and the state of Alaska. Because here in Simmons v. Parks, you see in 2014, the state is arguing that Alaska tribes again have no inherent civil jurisdiction over non-members in a child protection matter. So even though they have jurisdiction over the children, they may not be able to have jurisdiction over the non-member parent. Thankfully, the court rejected that jurisdiction or rejected that argument. And then in 2016, we have the state of Alaska refusing to recognize tribal court orders from the Central Council, Tlingit Haida Indian Tribes of Alaska around enforcing child support orders. Again, thankfully, we had a good decision from the court in that case. We do see some change in 2017 and continuing today. We have an official opinion from the Alaska Attorney General on the legal status of Alaska tribes. That opinion was not meant or designed to state new law, but to summarize where things stood after litigation in Alaska. So we have a clear statement that tribes exist in Alaska. Alaska tribes are governments with inherent sovereignty, and it summarizes the areas where the scope of that sovereignty is clear. During 2017, we also have the Alaska Tribal Child Welfare Compact, which continues to this day, and it essentially provides a framework for tribes to assume certain responsibilities that OCS has had and provide those responsibilities and services in ICWA cases. So what's the main message here? Well, one takeaway that I think is important is that none of this stopped tribes from continuing to provide justice and safety in their communities, right? That this hostility and this litigation did not stop tribes and village councils from addressing the issues that were important to them in each community. These can be children's cases, child protection and child welfare cases, or community concerns like bootleggers and alcohol and drug importation. And most recently, this has continued during the COVID crisis, where we assisted tribes in drafting model laws around COVID to protect their communities. So we've breezed through a lot of history, but the biggest takeaway is that after statehood, tribal justice systems didn't disappear. And the other important thing to keep in mind as we move into talking about Vawa and the Alaska provisions is that the state has never been in a place to provide a stable footprint of law and justice in every Alaska community, right? That many communities in Alaska have no full-time permanent state law enforcement presence, and that they may be waiting hours and days for law enforcement response to concerns in the community. Here's a summary of the types of cases that I mentioned that Alaska tribes are hearing. And each community is different. What may be a concern in one community may not be a concern in another. So they're tailoring their responses to the issues in each community. So we've heard both Kelby and Kelsey talk about Oliphant. And Oliphant is certainly part of where it all started, but also Oliphant included some language that said Congress could fix this. Right? And that's where we focused our efforts, asking Congress to fix this. So in addition to the general Violence Against Women Act authorizations and reauthorizations, there has been sustained effort in Alaska to find a solution crafted to fix our specific issues. So much of the resistance in Alaska has been around creating additional Indian country, right? And the concerns around creating additional Indian country. And in 2009, perhaps a little bit earlier, were some of the first discussions and attempts at federal legislation to craft a jurisdictional component, a land-based jurisdictional component that didn't include Indian country. And you see here a timeline of some of those efforts. I'm not going to highlight each one for you, other than to say that each one of these efforts required sustained attention and commitment of tribal leaders and advocates throughout the state, and not giving up along the way. We had the unfortunate 2013 experience where Section 910 said that Alaska was accepted. We have a fairly quick correction of that in 2014. And in 2015 and 17, or during the time where we had the Alaska Attorney General opinion and the Tribal Child Welfare Compact, we also had some negotiations with the Alaska governor and the AG and the Alaska delegation around these issues. And again, these attempts to find an Alaska specific solution to an Alaska problem. In 2019, Representative Young continues to put forward this idea. You see here some shifting attempts, right? And I think that that's interesting in the sense that, there were several tries to make it right and to make it fit. And while not an attempt at federal legislation, I think that Attorney General Barr's recognition of the crisis in Alaska and declaring a law enforcement emergency in rural Alaska is a key point here, in that we have some sustained federal attention and recognition of the dire circumstances here and the need to fix it. So starting in 2019, we see Senate Bill 2616, which is really the end game, the final iterations of where we ended up in this idea. And things moved much more quickly, I think, at least than I expected, starting in 2021 with that discussion draft, some bipartisan Senate Committee on Indian Affairs hearings and testimony, and then the introduction and the quick passage in 2022 in the Omnibus Appropriations Act. So that is the history of how we got to where we are. And I don't think I did justice in that short history, but I hope that I highlighted the most important points to keep in mind as we now turn and walk through the Alaska specific provisions, the Alaska Tribal Public Safety Empowerment subtitle, and that's subtitle B in Vawa. And I'm going to kind of walk through the sections in order and highlight what I think is most exciting and important about them, and then talk about some of the terms that are used that are new and how they are defined. So we have section 813A, and this is not the pilot project. This is a statement of what we believed to be true, but it's a reaffirmation and recognition from Congress that Alaska tribes occupying a village can exercise criminal and civil jurisdiction over all Indians present in the village. And so this does not break ground in new law, but it is a statement from Congress about what the law is. So what's an Indian tribe? It's a federally recognized tribe. We're going to delve deeper into the definition of village in the next slide. Inherent authority, right? That's not delegated, that's inherent. And in the village, that is now the territorial jurisdiction component that we have been lacking in Alaska. So we now can point to some territory where this jurisdiction resides. All Indians, that's all Native people, regardless of local membership or citizenship. So that means that you don't need to be a citizen of that village or the tribe in that village to be subject to criminal and civil jurisdiction. What is a village? Well, we refer out, or the statute refers out to ANCSA. And there's a definition in ANCSA of native villages. And then in the census, the Tribal Statistical Areas Program, there are maps. So in combination with that list of villages in section 3 of ANCSA and that map, we now have an idea of the territorial jurisdiction bounds of tribes in Alaska. Section B is a statement around civil jurisdiction to enforce protective orders, right? So what's a protective order? It's defined elsewhere as an injunction, restraining order, or other order issued by a civil or criminal court for the purpose of preventing violent or threatening acts or harassment against, sexual violence against, contact or communication with, or physical proximity to another person. And this is where, again, that territorial jurisdiction is important because it includes this ability to exclude violators from the village, from the territory. We have had ongoing struggles in Alaska around the ability to exclude bad actors and from the village. And this makes it absolutely clear that that can be done. Next, we turn to the special tribal criminal jurisdiction and the pilot project. And I think that these areas are getting a lot of discussion, as they should. But for my reading, section A is one of the most exciting sections, that reaffirmation. But this special tribal criminal jurisdiction, this is what Alaska tribes were shut out of. In 2013, where it said that Alaska tribes could not participate in exercising this special jurisdiction over non-Indians who committed violence in our communities. We now have a pathway to access this and to be able to protect our communities from non-Native people who commit violence. And many of these highlighted terms are terms that Kelby and Kelly went through. There's no different definition of these for Alaska than there is for the rest of the lower 48. I think it's important, though, to remember that, of course, jurisdiction is concurrent, as we talked about. It's not exclusive. And then Kelly talked quite a bit around the exceptions to the victim or defendant being Indian, around your, the folks working in the tribal justice system and perhaps in tribal health roles being able to be protected as well. What's next? Well, tribes need to apply and they need to meet certain standards around protecting defendants' rights. It's certain crimes, and it's that territorial jurisdiction, again, over villages. What does applying look like? Well, we're not quite sure yet. It's up to the Attorney General to develop a process to select Alaska tribes. And there is a preference given to Alaska tribes occupying villages that are predominantly Alaska Native and lack a permanent state law enforcement physical presence. We don't have a number, a percentage of predominantly Alaska Native, but I think that the intent is clear here. The other highlighted terms are around standards and covered crimes. So those standards are what Kelly shared with you around protecting defendants' rights. And the covered crimes are, again, that expanded list that's broader than domestic violence and recognizes the struggles in the lower 48 implementing tribes of not being able to hold people accountable for assaulting children or for other types of violence in the community. So I'm going to turn now to just giving you a brief summary of what the Alaska Native Justice Center does. And then I'm going to turn it back to Kelby and Kelly to talk about additional resources that are available. So the Alaska Native Justice Center has been here since 1993, and we were founded to address Alaska Native people's unmet needs in the civil and criminal justice system. And then we also provide training, technical assistance, and support to Alaska tribes in their justice systems. We have what we call tribal justice facilitators on staff to answer questions and provide coaching to Alaska tribes who are facing complicated issues or not so complicated issues in their justice systems and are looking for technical assistance and support. Here's our contact information. Please feel free to reach out. Thank you, Quiana, again, for the opportunity to talk with you. And I'm going to hand it back to Kelby and Kelly to share some resources with you.
Okay, thank you so much, Alex. A really fantastic overall presentations, a lot of great information here. I feel like I learn every time I hear you or Kelly speak in any capacity. I always feel like I learn I learned a ton. So thank you so very much. And I'm going to get us to the right slide. All right, perfect. Current slide. So we've got about 40 minutes, I believe, left for this portion of the presentation. So Kelly and I are going to really go over a couple of resources that are available in the Vawa space right now, and then open it up for Q&A. So if you do have questions or things that you would like to discuss, please feel free, put them in the chat. I've seen Nathan mention putting things into the chat. He'll ask your questions. Also feel free, he let me know, please feel free to direct message him if you don't want your question to be public. So that's also another option as well. If you don't want to have everybody stare at your question, you can also directly message him as well. With that being said, I want to quickly say one other thing before I go to the first slide with Kelly. Is the Intertribal Technical Assistance Working Group that Kelly also mentioned, the ITWIG, which was created in 2013. That body is really a place where not just tribal leaders, but prosecutors, judges, defense counsel, tribal advocates, law enforcement officers were able to really come together and share that peer-to-peer information. And we've had, during COVID, we've had virtual ITWIG meetings, and usually, outside of COVID, they're in-person ITWIG meetings. They have fairly regular phone calls, and all of that is free. And I will say tribal nations, and Kelly, I'm sure you'd back me up on this, but tribal nations are very generous with their resources that they have created over the years. I know Pasquayaki tribe has put together an implementation guide. There are several tribal nations that have model codes that they'll share with folks. So there's a real wealth of resources if your tribal nation is even thinking about VAWA, and the ITWIG is a great way to be able to have that peer-to-peer conversation. There's also a website, which I'll put in the chat here after we jump off the slides, that you can access a lot of these resources online that tribal nations, NCAI, TLPI, the Alliance of Tribal Coalitions to End Violence, and other organizations that we work with have built since 2013. So there's a lot of resources that there are a good base to continue building off of in VAWA 2022. So with that all being said, I'll move on to the first slide. And Kelly, I'd love it if you would be willing to jump in here to talk a little bit about the free one-on-one technical assistance that's part of the grant that so I'll back up and say that the Department of Justice, since 2013, NCAI has received a direct grant from the Department of Justice. We work with our partners, TLPI, the Alliance of Tribal Coalitions, to work together on this grant to help support the ITWIG, which we were talking about just a moment ago, but to also offer tribal nations direct free one-on-one technical assistance. And Kelly, I'll hand it over to you, since I know that you've done a lot of that really great work on the one-on-one technical assistance, particularly with the political considerations and code review.
Great, thank you very much. So just re-emphasizing what Kelby just said, a lot of this comes from working with the ITWIG and listening to them on monthly calls, talking about any issues they're facing with their tribal codes. The first bullet point here goes to something I think is going to be very important for Alaska. Alex may want to weigh in on this as well, but for those tribes and tribal villages that are considering moving forward with this exercise of tribal criminal jurisdiction or special tribal criminal jurisdiction, I know there may be the need to draft tribal codes. And that's something, I mean, we don't draft the tribal code and the one-on-one technical assistance, but we assist, we can give ideas, we can review your drafting and flag litigation risks or anything else, gaps. And so we have a team of experts that includes a victim advocate who's constantly perusing for victim safety issues. And so we're happy to do that. And then we typically someone from the group will meet with the tribe, sometimes two people. We occasionally, I don't know about now, but once we get past the COVID restrictions, would meet with tribes, sometimes one-on-one if that was needed. So a lot of support here for tribes to address drafting. How do we get started? Do we draft tribal codes? How do we even know that? I noticed that Kelby mentioned model codes. Let me just say a word about that. I think there may be some model codes out there for tribes to look at, but some tribes have really focused on making their tribal codes reflective of their own tribe customs and traditions, and have chosen not to follow necessarily word for word what other folks are doing. So I do want you to know we recognize that, and we're happy to work in any capacity that we can be helpful with code drafting, code reviews. Also the jury requirement, that's one of the due process requirements we talked about. And since 2013, I mean, this was a big deal in 2013 for some tribes. We have to put non-Indians on in our jury pool. Okay, let's make that clear. So some tribes had been having non-Indians in their jury pools all along. This was just not a big issue for them. Others didn't know how they wanted to handle that. What does that mean? How many do we need to pull in to be this cross section? And so the technical assistance providing group, we do have the nation's foremost authority on jury pools and how does that process work. And we've never had a jury trial before, so what do we need to do? So we do have a really rich resource section there that really targets the jury requirements. Let's see, we meet, as Kelby said, monthly with the ITWIG tribes. There's a special call for the judges and a special call for criminal defense attorneys. Then we have just a group call where sometimes cases will be discussed, or they'll reach out to a TA provider saying, I have this kind of case, not sure which way I should go with this, not about making the decision, but about following tribal law. What does that mean? Do you think it satisfies the requirement of Vawa 2022? So always there. We're there for you to assist in almost any capacity that we could be useful. I do want to say a word about just kind of reaffirming what Kelby said about the ITWIG. It is, since 2013, it has been my honor to observe these tribes that are out on the edge here, that are going forward with exercising this criminal jurisdiction that they, listening to Kelby, that they've always had, but that now some of these restrictions that have been placed by Congress and the Supreme Court being lifted. And what do we do, and how do we do it, and all of those kinds of questions the ITWIG just shares. They are so generous. And not only that, but they get together, and one tribe will, maybe a smaller tribe will say, well, we're worried about this. How did you pay for this? And the tribes share this. It's such a rich sharing environment. So I do want to give another shout out if you're interested in joining the ITWIG or gathering free technical assistance, or both. Kelby's put the email address here at the bottom. We would welcome working with you in any capacity. Next slide. Perfect. Oh, Kelby, it might be your slide. Sorry.
No, you're fine. No, I completely reaffirm everything that Kelly said. And it's, it's all of, and I just want to reiterate this. I know I put this on here. I put free on here twice just to say, like, this is all covered by other folks, by the federal government. This is all to make sure that people are safe in your community. So if you're, if you want to access these resources, you don't have to worry about, oh, how much is it going to cost for me to be a member of the ITWIG, or how much is it going to cost for me to request this TA? That's covered within the scope of our grant. We just want to make sure that we really let you know that there are these really great resources that folks have. And Kelly did a great job summarizing all of the items. I think in particular, one thing I remember hearing at one of our recent ITWIG calls, it was really helpful for the TA team to meet with the tribal nation specifically, not just on the monthly calls or the other calls that Kelly talked about, but being able to sit down with the tribal nation and really talk to them about an ongoing, if they have a Vawa case. There was a nation that had a particular Vawa case and had a lot of questions about how they were going forward with, I won't give too many details, but they had a lot of questions about how the case would go about, and just wanted to bounce that off the TA team. And I know that nation in particular really appreciated having the expertise that's within all of our organizations that we've gathered from across Indian country. And so I know that is a wealth of knowledge that please take advantage of, and please reach out at the email address. I'll drop it in the chat as well to be able to request. It's just the best central email address to kind of get those requests out to everybody amongst all the organizations that work together. So I wanted to take just a couple of seconds to talk about the Vawa resources available now. In the chat box, I put a link to the Vawa Resource Center. It's this ITWIG webpage that NCAI has really been working with our partners to build up over the years, and has a wealth of resources. TLPI also has several great publications that are very applicable in the Vawa space, especially as we come forward with Vawa 2022. Please take a minute and look at those websites, look at those resources. Even if your nation isn't just going to automatically hop into Vawa, it takes a lot of planning. And so, learning from tribal nations, learning from these resources could really set you up in the best position to be able to help people in your community when you learn from all of these different resources. Kelly, anything on the resource slide before I head over to tribal protection orders?
I would just add for folks, if you're just getting the planning piece of this going, to not forget victims' rights statutes as you think about code development, because that's a huge piece, allowing that victim to have a say in the criminal justice process. We do have a couple of resources there, how to design a domestic violence court, or if you don't have the resources for that, perhaps you say, well, we're going to here are domestic violence cases on one day of the week, so we could have extra security and resources there for victims. And the very bottom, the gray covered on the right-hand side, is crimes. It's how to put together tribal codes that focus on crimes committed against children. And so it covers child abuse, neglect, all in a criminal law format here. So that's available. All those are free for download at the TLPI link you're given there. Thanks.
Perfect. Thank you, Kelly. Last thing I'll say is the far left side, that's an implementation guide that the Pasquayaki tribe allowed us to be able to share with some folks. So please feel free to reach out. I know that they're very generous to let folks see the implementation guide for Vawa and Taloa that they put together. And I will say, I talked to them right after Vawa was passed and they were already working on updating that code to meet Vawa 2022, which was, they were on it. So I was really excited I was honored they allowed us to be able to share it with some tribal nations more recently. So please feel free to reach out for that as well. Tribal protection orders. Telly, I'll turn it over to you on this one, because I know that tribal protection orders, as we mentioned in Vawa 2013, very important in terms of getting protection orders in place for your tribal citizens and making sure that you have laws in place to be able to support victims within your community. And this is a great website as well. Kelly?
Thank you. So this is a website that really gets down to the nitty-gritty about how to draft a tribal protection order that triggers the federal full faith and credit mandate. Tribes are reporting, not all, but some, many tribes are reporting having difficulty getting their tribal protection orders enforced outside of Indian country. So this website will take you through a whole host of issues that you might face, along with providing tips on ways to beef up the tribal jurisdiction piece, how to get these enforced. Now, a little caveat, you'll see it as a second bullet point on there. This really has not been updated to reflect VAWA 2022, but the good news is VAWA 2022, with respect to protection orders and violation of protection orders, had no substantive changes. So this should be still good information. And so, yeah, just even what does my form, if I'm going to have a protection order form for the judge to fill out, or I mean, what would it need to have in it? So all of that is available here on this website. Thanks, Kelby.
Thanks, Kelly. Yes, full faith and credit and enforcement of tribal protection orders, particularly at the state level, is really important as well. The last thing I'll say before we open it up for our Q&A segment is this email, the tribal-vawa@ncai.org. Again, please feel free to email that website. I know Kelly and I also put our personal emails in there as well. The ncai.org tribal Vawa email is just a good centralized email where we can put all those requests out to the team. And so we were able to reach more people if you email that email as opposed to Kelly and I individually as well. So just wanted to make sure to put that up. But with that all being said, I know we have questions. Looking forward to a really great discussion here today. Really appreciate everybody's time. I'm going to bring up Nathan here to start the Q&A and open discussion portion, and look forward to questions that folks may have. Okay, Nathan, the floor is yours.
Thank you so much, Kelby. Yes, absolutely. We are ready for our Q&A, and there are several ways we can do this, and you are more than welcome, as we mentioned, to drop your question into the chat. Kelby also mentioned that if you're uncomfortable with your name or anything being associated, or you don't want to say that so publicly, you're more than welcome to direct message me, and I will be glad to ask your question for you. For those of you who may even be more comfortable the other way, we would invite you to interact with us. You don't have to use the chat. If you can look at the bottom right to your reactions and click on reactions, you'll notice that you have the raise the hand function. That will ensure that we see you. And so you are welcome to ask your question aloud. And if you are comfortable, we'd love to see you on camera if you're comfortable initiating your camera and interact with you that way. So any questions that you might have. And as our participants are thinking of questions, and I think it would be a good opportunity, to also just say thank you to everyone who worked so tirelessly to ensure that VAWA was reauthorized in 2022 with these specific expansions. Anytime we see tribal sovereignty and tribal jurisdiction expanded, it is a reason to celebrate. So thank you to all of you for your subject matter expertise in showing us how those expansions were put into place and the implications for Indian country, what that means for tribal sovereignty, what that means for tribal jurisdiction. And I know too that the title of our session together is Protecting Native Women, and the very real issue of gender-based violence, which we never ever want to set to the side. But I think it was so wonderful to hear that these expansions protect women, they protect children, they protect men. The potential protective factors in this reauthorization are just wonderful. And so again, a big thank you. Encourage us all to thank those in our lives who worked so hard and hundreds upon hundreds of hours. We know that so many of you put into ensuring that this reauthorization happened. So thank you, Yakoke, deeply from Indian country for your work. And again, we just encourage you, if you have any questions, to put into the chat or raise your hand, or you are free to unmute yourself. You can absolutely do that. And the panel, I would like to ask you too, at the National Indian Health Board, we talk about our mission being to serve as a united voice for all of our federally recognized tribes. But one of the things that we point out is that the diversity among tribes is so important to consider. And Alex, you spoke to that, especially not only the diversity from Alaska to the lower 48, but the diversity within Alaska and the diversity within the lower 48. There is so much diversity that should be respected and so much different lived experience. As we think about this particular Tribal Public Health Summit, Vawa is complex. It has so many intersecting components, so many things, and so much potential in terms of what components are affected. Can we think of it, maybe couch it in terms of public health for a moment, perhaps access to justice, how access to justice impacts the health of our Native communities? Can anyone speak to that? Or
Nathan, I'll hop in because I know that I included it on one of my slides. But in my mind, it's very clear. I folks don't know this, but I was born and raised in my nation's reservation in southeastern Oklahoma. I'm from Buffalo Valley, Oklahoma, and the access to justice that people have, whether or not they know that police will actually show up, right? If they call the police, can the police show up to be able to stop a very violent situation? Can they even go to a court system? A lot of times in Indian country, when tribal nations don't have jurisdiction and the federal government has jurisdiction over particular crimes, the crime is prosecuted hundreds of miles away at a federal courthouse with prosecutors that are not in our communities. That's a big reason why we really pushed in Vawa 2013 to restore tribal jurisdiction, because a lot of those crimes were just being left on the wayside. And it is very important, at least in my mindset as somebody who's grown up in Indian country, to tout that public safety and health in your communities is completely combined. If you know that no one's going to come or no one's going to care that you get attacked as a Native person or that you have a crime committed against you, again, hunters know where to hunt. People know that they're not going to be held accountable. And so you might be afraid to come forward. You might be afraid to come forward with the abuse that you might be experiencing or the crime that happened to you or a family member because nobody cares. So restoring tribal jurisdiction in my mind is very preventative because it empowers the community to be able to have holding bad actors accountable. I said that, I know Alex and Kelly both said it, but holding bad actors accountable is so key to making sure that your community is healthy and that your community is safe. And I know that Alex and Kelly might have something else to add in here, but to me, access to justice is very much tied to the health in our communities out in Indian country.
Yeah, Nathan, thanks for the question. I think it's a very interesting one. And I think the thought I would offer here is that, public safety and justice is one component of a public health response to some of these issues, right? We know that family violence, domestic violence, child sexual abuse, these are complicated issues. And if we are siloed in how we respond to them, I don't think we're looking at the issue from every possible angle. And here I would point to, I think the CDC has a draft framework around responding with a public health approach to some of these issues that's helpful to look at as a framework, perhaps for tribal nations to respond in the same way that we are not just acting on our own, right? And if we have a robust tribal health system, how do we build out a strong tribal public safety system to complement that? Or for nations that have a strong public safety system, but not so much a health system, how do you build that out? Because really to respond with that public health lens and framework, I think is a promising practice, and I'm glad to be talking about it here.
Thank you.
If I could, I'll just add one little thing onto this with respect to access to justice. And again, I mentioned this during my presentation. For tribes that are moving towards exercising VAWA 2022, for tribes who are issuing civil protection orders and wanting to civilly enforce those protection orders, I think it's really important, more so probably in the criminal realm, to be at least thinking in the back of your mind about victims' rights, because these are rights that in a criminal case where the victim is the victim of crime, they are going to have the right to protection. I'll just give you some general ones here. They're going to have the right to a victim impact statement after the defendant's convicted and before the defendant is sentenced, to talk about how that crime has affected their life, impacted their life, and their families' lives. There's the right to privacy. There's the right to protection from harassment, which I found working in a victims' rights clinic very, very important to child victims of sexual assault, being able to keep the perpetrator's family from lining up outside the school to harass. I mean, just a whole host of issues. It gives the victim a say and access to some of those rights that might promote healing and certainly will focus on safety. So again, if you're interested in drafting any of those while you're drafting your other pieces of your tribal code, please reach out.
Thank you for that, Kelly. We do have a participant question who asked is it possible to get our Indian clinics to conduct sexual assault rape kits? Is that possible?
Go ahead, Kelby.
Oh no, I don't. I know that's been a very big component in Indian countries, making sure not only do you have the jurisdiction to be able to prosecute a case, but to gather evidence in your communities. I know one of the biggest pushes that I saw. So for those people who don't know, an ally that we have in Indian country is Angelina Jolie. She really focused on the tribal provisions and a couple of other really important provisions, children provisions. One of the provisions that she very much focused on was getting language into VAWA that focused on updating technology and getting better technology to detect bruising across different skin tones, because as you can tell, in Indian country, we come in a rainbow of colors. That is the antithesis of being a tribal citizen. There is no one size fits all for tribal citizens across Indian country. And so the ability of your IHS clinic to be able to detect bruising when somebody tries to strangle one of your tribal members will be really important. So that I know was included in STOP grants in this new VAWA reauthorization. They have to actually appropriate that funding. So that's the next step for all of this VAWA funding, is actually getting appropriations for there. But I do know there was a lot of, there's new funding coming into VAWA 2022 that's specific to the health space for different components. And I know sexual assault nurses is part of that authorization, or not authorizations, but part of that funding level in VAWA 2022. Kelly, I want to turn it over to you because I don't want to misspeak here, but I do know that this has been an issue in Indian country that folks have been talking about, is the ability to collect that kind of evidence.
So I would encourage the person asking that question to reach out to that email address that Kelby gave earlier. There's the National Sexual Assault Nurse Examiners Organization that might be able to provide you with some really good information about where to get the kits. I know Kelby also, I think in the omnibus, there was a provision about getting the rape kits tested more quickly. So, but for the kits themselves, please just email us and let us provide you some contact with the National SANE organization. They would be able to give you the freshest, most up-to-date information on that.
Yes, thank you for that very good question. Thank you, and thank you for taking the time with that. I think too, as we've had several questions about when Vawa was first announced, the reauthorization, and we kind of waited to see when was this going to happen. And as you mentioned, Kelby, kind of at the nighttime if you're staying awake looking and you hear that announcement, when we hear the publicity of the announcement, I think frequently there's an assumption that, okay, we have this, now it's automatic. And all of these provisions are just there they are, and so this just goes into effect. And as you've mentioned in your presentations, there's actually a process, for one thing, in terms of when these actually go into effect. There's a process for exercising VAWA. And so for those who are asking, how do I find out if my tribal nation is actually exercising or plans to exercise VAWA, what some of those barriers might be, and what assistance is out there? How do we find those answers, and what are we really looking for in that?
Well, the first thing I'll say, Nathan, is there is a chart, and I'm grabbing the link right now. So there is a chart, and I put this in the files earlier on the NIHB platform, but there's a chart that showcases what tribal nations are implementing VAWA jurisdiction as of February this year. More tribal nations could be implementing, if they're implementing VAWA, if they're implementing TLOA, the Tribal Law and Order Act, if they're members of the ITWIG. So that chart is a really good way to figure out, hey, is my tribal nation actually involved in this area? If not, can I contact my tribal leadership about getting involved in this area? And so that chart that I just put in the chat is a great resource for folks. And then in addition to that, I think it's also really important to just know that VAWA is not a light being turned on. It's, tribal nations had to be really thoughtful about being able to exercise VAWA. As Kelly mentioned, there are certain requirements that tribal nations have to put in place in their codes to be able, and certain protections that they have, the habeas protections, for example, defendants protections, victims protections. There's certain things that have to be in place in order for tribal nations to exercise this restored jurisdiction, and it costs a lot of money. But one advantage is in VAWA 2022, we got the levels for funding from 5 million to 25 million, which we're really excited about. And now we just need to go to Congress to tell them to appropriate that money. So, barriers that I've heard from tribal nations, and I know that Kelly can definitely expand on this much more, but barriers in particular have been, lack of tribal jurisdiction over certain crimes, right? Like that crime that you mentioned, crimes against children, stalking, sex trafficking, many of the crimes that we mentioned that got reauthorized. It's been funding, and it's also been reimbursements. So we've had a situation where Eastern Band Cherokee tells the story where they had a tribal prisoner in custody. That tribal prisoner went and got injured when they were in the Eastern Band Cherokee's custody. And then the tribe was on the hook for paying for the healthcare cost of that non-Indian inmate, several thousands of dollars. Indian Health Services didn't cover that cost. And so because of that story and similar stories from tribal nations, we were able to get a reimbursement program put forward in VAWA 2022 that we're excited to work with the Office on Violence Against Women on, and with all of Indian country on, to make sure we have a reimbursement program that works for tribal nation that meets these needs and really helps overcome a lot of these barriers. With that being said, I know that Alex and Kelly have a lot of great info for this really fantastic question as well. So I'll hand it off to them as well, because there's a lot of good information here too.
Sure. So what I'd add here, Kelby, I really like the character, like it's not automatic, right? So you're not, your tribe is not going to be rushed into this. Nobody's going to suddenly say that this is how you have to move forward. And my memory is that most of the act becomes effective on October 1. I think it's written in an interesting way in the statute. It's like the beginning of the fiscal year after this one. So we're referencing the federal fiscal year is when these changes become effective. But again, for Alaska, the AG needs to come up with a process. And we don't want that process to take too long, even though we've got to wait until October 1 for it to be effective. Doesn't mean that the AG and the secretary should be waiting until October 1. So we're hopeful and advocating that that process is being explored now, so that when October 1 does come around, everybody's clear about what's needed for the next steps.
Thanks, Alex. I just, and please add to this if needed. I'm just thinking, as tribes maybe in Alaska are sitting down to think about this and meet on this, and again, like you pointed out, Alex, we have to wait on those processes to be published, so we'll know exactly the steps. But just sort of working with the ITWIG since 2013, I feel like one of the first steps that tribes that have constitutions, not all tribes do in the lower 48, but if the tribe in Alaska tribes, the villages have tribal constitutions, I'd want them to take a look at those, just a review, to make sure the jurisdictional pieces don't say jurisdiction over Indians, because that will require a constitutional change if they want to now start exercising over non-Indians. And that happened to some of the tribes in the lower 48. They had to go amend their constitutions. And sometimes that can be expensive, especially for some of the larger tribes, or if you have a constitutional amendment process that requires elections and different things like that. So that's a first step. The second step, I think, is to sit down and think about these codes. Are they going to be in writing? Some of the requirements that I think you would run into is that the criminal laws have to be publicly available. That might mean different things for different tribes, but definitely sort of implies that they're going to have to be written down. So I'd be thinking about that. The TLPI resources, there's resources on drafting a tribal code that complies with the Tribal Law and Order Act, which is one of the requirements. So there's, how to draft domestic violence codes. There's just a lot of different publications on that website that Kelby provided. Those are, and the victims' rights piece. We do have a how to draft victims' rights code publication coming out, but we're waiting on final approval for that. So I don't know how long that will take from the funder. So I would be really thinking about that. And I just appreciate Kelby bringing up, those of us who have been working in this since 2013, so many things we didn't think about. We've learned, but we were so intent on interpreting the new laws that we had to wait for the tribes to get going before we could actually address some of the issues that were coming up. The healthcare issue, who's responsible for the healthcare of the non-Indian that's incarcerated by the tribe. Another, some of the criminal non-Indian defendants were pleading they were incompetent. And then there have to be these, competency exams. Some tribes didn't even have a process for that. So I want to encourage tribes that so much has been learned from the ITWIG, so much we can share with you. Encourage you again to join that. And one step at a time, but it's doable. It's doable, especially with some of the funding bumps that we got in VAWA 2022.
Thank you so much. We're about coming toward the end of our time, but we do have time for one more question that I'd like to present that a participant has asked. That has said, it is good to hear the initiatives in place to get more equitable training for clinicians to properly treat survivors of violence, referencing Kelby's example earlier about recognizing bruising in different skin tones. Our participant wants to know if there are specific efforts as well to get equitable training for clinicians when it comes to treating queer, transgender, and/or two-spirit survivors of assault or violence.
So that's a really great question, Nathan. There's nothing in the tribal provisions. So I'll say this. There are tribal provisions that are within a tribal title, and that's called Safety for Indian Women. And that primarily focuses on the jurisdictional components of VAWA. So all the court-related items, health-related items, and items for clinicians will be in, I believe it's Title V. It's strengthening the healthcare systems portion of VAWA. That, to my knowledge, at least, is not gender or sexual orientation discriminatory. And there's actually a lot of new grants that are coming out of there that tribal nations actually have set asides under those particular grants. So there's grants for public awareness campaigns and for sexual assault care and systems. In addition to that, there are a couple of reports coming out on maternal morbidity and mortality rates, on the healthcare systems across the country, sexual assault services across the country. I will say that as part of the National Task Force on Domestic Violence, so that's a larger coalition of domestic violence, sexual assault organizations across the country, and NCAI, along with other organizations, are a part of that particular bigger body. The NTF overall has been very inclusive for LGBTQ issues within the VAWA space, and I know that we actually have a subcommittee. So like there's a tribal subcommittee within the NTF that NCAI is a part of, and there's a subcommittee that looks at violence against LGBTQ individuals. And I know that they went over this bill with a fine-tooth comb. I also know that there is, while this isn't exactly on point to answer the question, that one of the things that we did get in VAWA was a resource center that is specifically focused on LGBTQ individuals across the country as it relates to violence against them. And so that's going to be a whole new resource center that is specifically focused on not Indian country specific, but much more focused in the LGBTQ area. And so I don't have an answer for clinicians. There's nothing, at least in my most recent read of the VAWA bill, that is directly on point to the question. But I would say, look at the resources, particularly in Title V of VAWA as it passed in the omnibus bill. If it's not restricted and says that you can't do that, there probably is really good flexibility for your tribal nation to focus on those communities out in your nation as individuals that need specific needs out in Indian country. And each tribal nation, just going back to Nathan, your question about diversity, every tribal nation is different. As you mentioned, two-spirit individuals. There are individuals that were here, terminology, what's the best way to say this? Indian country is very diverse on all of the great people that are within our communities. And so how you handle violence in your community will be very reflective of it. And so think outside the box. If it doesn't say you can't do that in the bill, there may be an opportunity for you to get federal funding to help clinicians address the needs of LGBTQ survivors out in Indian country and out in your area specifically. Kelly, Alex, I don't know if either of you might have an answer for that particular question.
No, I think you handled it really well, Kelby, and I know that we're out of time. The thought that I would add here is that I think that tribal leader testimony on this issue is really powerful. I know that over the last handful of years, during the annual VAWA consultations, there have been tribes who have been sharing this point and speaking up for LGBT citizens in our communities and talking about their specific needs. And the feds have to listen when we say that. So there's another avenue to raise it.
Thank you so much. And yes, we are at the end of our time, but I do want to remind everyone who's participated today, though, to thank you first and foremost for your participation, but to know that even when this Zoom link ends and the chat here disappears, you are able to continue any conversations in the actual Pathable session chat. So if you have any follow-up or if you would like more information, you are more than welcome to post in that particular chat box. All of us will have access to that, continued access to that. This has been recorded, and again, it will be uploaded soon, so you can review this later or tell all your friends who may have had to miss out on that it will be uploaded so that they can hear that later. Thank you so much again to Kelby, Kelly, Alex. We appreciate your subject matter expertise, of course, but we also so sincerely appreciate the passion and the energy and the time and sharing your heart with us for this issue. We know that it is personal to so many, and the experiences, if we had more time to share, are harrowing, but also hope for survivors now. And again, that expansion of tribal sovereignty, respect for tribal jurisdiction, it is exciting time. And so thank you so much for sharing your time with us. We encourage everyone to fill out that evaluation that is on the end of, or at the end of the session. There is a button that says, please fill out this session's evaluation. So it's very clearly laid out there in terms of the instruction. Just click on that. But we would appreciate any feedback that you can give us. So thank you so much, the participants. Thank you, presenters, for your time. Hope you have a wonderful day. May the blessings of the Creator be with you. Yakoki. Thank you.